So welcome everybody to the Vocational Science of Freedom Saturday online law class. And tonight we'll be talking about the Vocational Science of Freedom status documents. The documents can be downloaded and found on class 4 in the Vocational Science of Freedom Gilded server. And the link can be found to join the Vocational Science of Freedom Gilded server on the Vocational Science of Freedom YouTube channel. And the status docs are a set of docs which we have created over the last 25 years to rebut the presumptions of which the corporate state uses against you. And so tonight we'll be going over the general handbill for the docs, which is entitled in the mega download server, which you can find on the Vocational Science of Freedom Gilded server. And when you click on the link, it will take you to a download, and all you have to do is click on download, and then you'll be able to look at this particular document entitled General Handbill for the Status Docs 1.3. So the handbill for the Vocational Science of Freedom status documents, as it shows, the status documents of the Vocational Science of Freedom are used to correct the state and federal public records, probate records, and private records of your house as they pertain to who you are in relation to the government, both state and federal. What the docs also do is put your will onto the public record regarding the unlawful administration of your estate. I'm going to pause here for a minute. The unlawful administration of our estates has been a culmination of what the attorney, meaning the Knights Templars out of the City of London, meaning the Inner Temple and Middle Temple courts, Inns of Court, right, which were established by the Knights Templars in the City of London, and the City of London was established in 43 AD by the Romans. Okay, it is a private city-state, very much like the Vatican. It has its own rules, has its own law, and the Queen of England, or King of England, must literally ask permission in order to enter that particular ground, because they do not own it. Now, what we won, meaning we, the American people, won, and our ancestors won, through force of arms against King George, the attorney has taken back from us by force of insight because we have failed to learn the law. During the colonial times, every colonial household, pretty much, had a copy of the Geneva Bible and Blackstone's commentaries. Both of these two books enabled those in those houses to understand and know the law, and know when it was being unlawfully enforced against them. During English jurisprudence, the history thereof, through the mid-1500s up until the late or mid-1600s, there was a specific court, which was called the Court of Wards and Liveries. That court was the court that you would go to in order to what was called sue out your livery, meaning sue out the livery of your estate. Livery is the root word of delivery. De meaning of or from, and then livery meaning to have and to hold or to be given. Okay, so you have this understanding in English jurisprudence that everybody knew that you had a guardian and that you had to go sue out your livery. For those who had estates that were considered to be either abandoned or lost or unknown as to who owned them. If you read the Cestui Que Vie Act of 1666, it will specifically state that in order for you to claim your estate, you must prove that you have been found to be living and that you must do so in an action, meaning an action at common law. Now, the attorney and the Knights Templars out of the City of London have destroyed our common law. They have removed any possibility of which we would have had or would have known that we could have had for remedy. They have specifically done this so that all of us are seen as incompetent, infants, and literally dead to the law. Now, what the Vocational Science of Freedom status docs do is correct these presumptions. I have uploaded the all-day law class that we held many months ago regarding the rebutting of presumptions. All of those can be found on the Vocational Science of Freedom YouTube page. And I highly suggest that everybody go through the entire class of rebuttable presumptions, the whole entire thing, and learn and verify for yourself every single thing that is stated in that class. Now, from the standpoint of correcting the public record, there are multiple presumptions that they use against us. You'll see this, well, you would only actually see it and understand it in their inferior courts that are not of record once you go through that class. But once you do go through that class and you start to learn the law as to all the aspects of law, meaning the 5 jurisdictions of law and probate and every single thing that the cult of Rome has been doing to control your estates, you'll see that we had to create and develop our own proper remedy as per law, proper law, public law and common law, and natural law, and the rights of blood and kinship through these status docs that you can then stand on and say, no, this is who I am. These are the oaths that I hold and only hold. And no, there are no contracts of which you have over me or above me, because I have nullified every other contract that does not have my house seal and my signature upon it. Okay? So now to get back to the handbill. So what the status docs also do is put your will onto the public record. Okay. The importance of your own will. They have stolen your will through these presumptions. Literally meaning that, and I don't just simply mean a will from a standpoint that a will is something that you write down to protect your assets after you're dead. I literally mean they have stolen your will from a standpoint of what you will to do in this life. Do you write your own life script? Are you sovereign? Do you hold title to your property and to your land? And yes, property and land have 2 entirely different meanings. Do you own and have control of your estate? The substantive definition of your estate is everything that a man or woman owns in law. They have done everything that they can possibly do to place presumptions, to literally what's called interplead. And this is an aspect of the Westminster statutes. Literally, what the attorney has done has come into a capacity and the ability to interplead. That means to get in between the heir and his estate and his property, to interplead before he has the capacity or she has the capacity to claim what is theirs, to claim their birthright. That is the aspect of interpleading. And I now implore everybody to look up the term interplead and to understand that term. So do your homework. So anyway, to get back to the handbill. All of the people's estates are being administered under the presumption of death, abandonment, infancy, and incompetency. Incompetence, the aspect of the presumption of incompetency usually comes when a sovereign American stands upon their substantive rights and is a belligerent claimant of their substantive rights in one of these inferior courts of record. What they will do, what the black-robed priest of El will do on that bench, the second that you start to talk in these ways, they will instantaneously ask or demand or state that we need to have a competency hearing. Sometimes the district attorney will do a verbal motion right there in court, which you have to pay attention to, because say you're just sitting there in traffic court, and sometimes the district attorney will say, Your Honor, we come upon a motion of competency, or they'll say, we come upon a motion of competence, or there's a lot of different ways that they do it. But the point of the point in the aspect of the presumption of incompetency is it goes directly to soma. Soma is psychology. There's three ways that the attorney takes from you: meta, soma, and veta. All these being Latin terms. Meta being medicine, soma being psychology, and veta being law. If they can't get you in law, if you show that you can come over the top of them in law, they'll instantaneously go to soma, psychology, and say, oh, they'll use a pseudoscience called psychology to say, oh, you're not competent to handle your own affairs. You must be crazy because you're coming before us and standing upon and being a belligerent claimant of your substantive rights. Now, the other presumptions, the presumption of death, that's a 7-year thing after your mother and father abandoned you at the Foundling hospital. A foundling being an infant, the definition of a foundling being an infant of unknown parentage, where your mother signs a birth certificate contract of which she literally becomes an informant. She informs upon you. She becomes an informant against you. Now, not to say that all the mothers and all of our mothers knew that they were doing this. Of course they didn't. Somebody just simply handed them a form and they said, fill this out. And they probably threatened them if our mothers or fathers even started to question why. Right? The first question one should always ask, why? Why they did this? They will instantaneously argue to them and say, well, because you have to. Sorry. Who has to? No, this is an aspect of volition, of free will. The violation of our volition is the single most important thing that everyone needs to remember as to what the attorney is doing. They always give you something so that you will violate your own volition from the aspect of contract. And what is a contract? It's an agreement. Furthermore, what is an agreement? It is consent. As Jefferson said, the just powers of government are derived from the consent of the governed. If you do not give them consent, they do not have any just power. Period. We exist before government exists. And in this particular constitutional republic, we created the parameters of which this government exists. And we said, look, you guys get to do these specific certain things, and we vest you with these particular powers to go do what we do not wish to on a daily basis have to worry about. And yes, you do get a salary and you get to go do these various different things for us, but only under good behavior. The second that you come out of your box, meaning as a term in law, exceed your jurisdiction, we will stomp you into oblivion through our grand juries, which means 25 members of the peerage come together and investigate. The Supreme Court of the United States the Supreme Court of the United States of America and the United States, both of them, the corporation and the other, specifically have said that the grand jury is above our jurisdiction because it is specifically stated in all of the state constitutions and in all of the federal constitutions. Now, where does this power come from? It comes from the Magna Carta. It comes from the various different articles of the Magna Carta, of which I implore everybody to read and understand. That when 25 members of the peerage come together, literally they take over government. They take it over. It was the same thing in the Magna Carta when the 25 barons would come together and take over the government. They would literally take it away from the king. The Founding Fathers knew this, they completely understood it, and this is still the same way that you and all of us can control any aspect of local government and even federal government. Case in point, Nixon did not resign because he was being impeached from Congress. Nixon resigned because the grand jury that was after his ass was doing everything they possibly could to do a proper investigation, and he knew that once that investigation was over, he would be indicted for treason. That's why he said, bye-bye, I'm out of here. It was the people that took him out. Now, the date that we're talking here is January 16th of 2021. We are now embroiled in a situation of which the very republic may be taken over by communist influence. The reason is because none of us have acted the way we should be acting. And the first and foremost thing that we all need to do is to claim back our estates. The reason the United States Federal Corporation has so much power right now is because we have given it to them. We have registered our property and our estates through Roman civil law, Roman registry, which stems all the way back to the New Deal, 1933, where the state governors went to Washington, to Roosevelt, and said, yes, we will pledge all of the registered property of which the people have registered on the state registry and county registry registrars as collateral for loans to a private banking cartel run by the Rothschilds. What we are doing with the Vocational Science of Freedom Status Docs is eradicating any presumption that we agree to this. After you do this, you have two choices. Either you stand on it or you go back to being a slave. That choice is entirely up to you. But know this: the Luciferian fools who run the Bar Association and who run the international banking cartels see you as chattel. They will always see you as chattel and nothing more. And that is why it is so important for everybody to do their doc set. Now, I have heard over 25 years of doing this, that there are many other human beings out there and many other quote-unquote gurus and other people, some of which are less than reputable and some of which are clearly agents, who have tried to put forward documents to say, oh, just sign this and just do this and you'll be free. Anyone who stops at that, you should automatically know is an agent. What we do here at the Vocational Science of Freedom is to make sure that every single human being, every single one of the people who chooses to do this doc set is given every single thing that they need as far as the information is concerned as to the who, what, when, where, why, and how of every aspect of this doc set. What we may not know, if you ever give us a question of which we cannot answer, then we say to all of you, we will figure it out and we will learn it together. We will learn our way forward together. Regardless of what happens in the next few days or the next week is absolutely 100% irrelevant. The only thing that matters is that we move forward to establish our houses and to establish our sovereignty on the public record and declare it to be so. And that we make sure that we stay together from the standpoint of petite juries and ultimately grand juries of 25 members of the peerage on the county level to make sure that we can enforce it. And people have come to me and they said, well, how do we enforce it? You enforce it by the Second Amendment. The Second Amendment is not there because we have the right to go out into the woods and bring back sustenance. The Second Amendment is there in all of its glory to be at the same equal level that gives us the right, because we have the right, because we created the government, remember, to have the exact same force and power that they do. Does the Second Amendment mean literally to its absolute fruition that we can have nuclear weapons? The answer is yes. Would those who dare to control you say that that answer would be no? Of course they do. And why? Well, I think the answers are obvious. So, to get back to the handbill now. So, much of this quote-unquote administration was the result of the New Deal. When the state governors committed treason against the people of the states governed in 1933 and unlawfully pledged the registered property of the people from the states to the federal government for the loans for a private unlawful banking cartel known as the Federal Reserve System, as I just did it. A lengthy overview of what happened was revealed in a quote from a man who was Woodrow Wilson's handler, meaning the man who controlled him. Woodrow Wilson was nothing more than a educated college professor who was very good at writing speeches. The man who actually controlled him was a man named Edward Mandell House. And in this radio interview, I explain what happened, which I give a hyperlink to, which I'll copy and paste into the classroom. Now, to get on to the presumptions. The death presumption kicks in after 7 years. Because no one comes forward to you nor anyone, because of course being 7-year-old, how would you ever know to do so? Because no one comes forward to claim you at the Foundling hospital that your mother abandoned you at when you were assigned the birth certificate. The infancy presumption stays in full force and effect until you, quote unquote, come of full age, as contemplated in the Magna Carta in Articles 3, 4, and 5, which is still the common law to this day in America and every other common law realm of which the British ever held the empire over. And the incompetency presumption stays in full force and effect until you correct it on the public record, meaning you do so by a proper proof of life and proof of age and competency inquest by a judicial coroner. Now, your judicial coroner can be anyone who you wish who has a medical license. Now, the only reason that we've done this from a standpoint of stating that one should have a medical license from the state is so that the corporate state can never argue the fact that, yes, you were the ones that gave them authority under such and such license to deem someone to be living and dead, right? So on and so forth. That's basically it. Beyond that, any sovereign can hire, declare, recruit, whatever you wish to state, any officer of their own court. You can see this in even the federal rules of civil procedure. Look up the federal rules of civil procedure and look into what is called a special master. You will see that anyone can appoint a special master to their own court. And the only reason that any special master would not be allowed to be a special master in a sovereign's court would be if the defendant objected to that appointment. But unlike U.S. District Court being a court of maritime admiralty jurisdiction, our courts of record in the county jurisdiction are not subject to those rules. So to continue. So the incompetency stays in full force and effect until you've claimed your estate and done so in correcting these presumptions, and that you fill out your livery of your estate from the aspect of doing the status docs. Now, we thought for a while that we would have to do this in a formal probate case, which there's still some people that are interested in doing so, and we will keep everyone up to date as to what those particular cases, how those particular cases turn out, or the problems of which might arise in one way, shape, or form in filing those cases. But what we came to the conclusion of is that, okay, if we've already summoned if the judicial coroner of our own house has already summoned the petit jury to do the proof of life and proof of age inquest, then at the same time, there's no reason why that same petit jury cannot confirm the validity of the rest of the status docs and simply state as a judgment of that petit jury that this man or woman has claimed their own estate and has sued out their livery. So that's the final status doc which we're now working on. Okay, so this goes out to anyone who's already had or purchased the entire status doc set. Everyone who has had or purchased said shall get a copy of this final document. So to continue. So a practice that was well known during the times of court and wardens and liveries in England, meaning to sue out the livery of your estate, has purposefully been occulted from us so that we never have the ability to make proper claim to what is ours. Now, these are the main presumptions that are working against you. This is a fairly long list, but it's not an absolute 100% exhaustive list as to what they are. But I'll now read them. List of presumptions that the vocational science of freedom status docs will rebut are as follows. 1. That you have not been found to be living, and that you are a decedent under the IRS code or dead to your own estate under the common law. 2. That you have not come of full age and are an infant under 1 USC subsection 8 under the definition of person, and are therefore not able to handle your own affairs. And once these are rebutted, they, meaning the fools and attorneys that would hold it against you, are now required to give your entire estate to you as per Articles 3, 4, and 5 of the Magna Carta, without fine and without fee. You have to realize that you are being taxed through the IRS, which is nothing more than a glorified accounting firm, for the use of your own estate through filing what's called Class 5 IRS forms. Class 5 IRS forms include, well, I shouldn't say the word include. That's not, I don't want to use an aspect of legalese here. But the Class 5 forms that I know to be Class 5 are W-9, 1040, and 1099. Those forms are what's called Class 5 gift and estate tax. Every single time that you file a W-9 form, you are not paying income tax. You are paying a gift and estate tax. Why? Because you haven't claimed your own estate. And the IRS is just there, as I said, as a glorified accounting firm to keep track of what? Abandoned and lost estates. So, on to number 4. On number 3. That you are not born of parents in wedlock. Where you are born thereof, you basically are considered a bastard by the birth certificate, and therefore are unable to inherit under the common law. This presumption strips you of the status as heir and to the protections of the constitutions themselves. Remember, what every single preamble of every single state and federal constitution states is that it states to ourselves and our posterity. That means the heirs that come from us, legitimate heirs. If you are not a legitimate heir, therefore you have been instantaneously robbed of all of the protections of the constitutions, both state and federal, by that single presumption under the birth certificate. Number 4, that you are not the sole lawful appointed absolute general rightful executor of your own estate. Okay, which is the all caps letters name that they quote unquote charge under the statute merchant or the law merchant for the things that they say you can or cannot do with your own body or in commerce. This is not, the all capital letters name is not a corporation, as never has been. It's your estate. It is a fiction of law, and some of the property of said can sometimes be placed into a trust with other names, meaning, say, John H. Doe, all capital letters, or Doe John H., or Doe John Henry. But know that the all capital letters name on your BC is the name of your estate, and it is not a corporation. All of the res, RES, meaning the property and value thereof, all res of any trust that they create originates from your estate. You have to have an estate first before you can have a trust. It cannot go the other way. It has never been able to go the other way. And anybody that tells you otherwise is a moron or a shill. Period. Full stop. Attorney or otherwise. Number 5, that you tell the IRS by proper documentation of number 4 above, meaning that you're the sole lawful heir and the general rightful executor. Number 6, that you tell the IRS, number 7, that you are a trustee of your own, that you are not a trustee of your own estate. Meaning every time you walk into one of these inferior courts not of record, one of these law merchant courts, they're presuming that you're the trustee of the all capital letters name of which they charge. You have to rebut this from the standpoint and walk in and say, no, Your Honor, I come before this court as having been found to be living and as the sole lawful executor of first, middle, last name estate. And then say, is there any objection to what I just stated? And you will see that court grind to a halt for a moment until the judge thinks about what the hell you actually just said, and then they'll grill you as to, well, what's an executor? I don't understand what you mean by executor. Objection, Your Honor. The term executor is clearly stated in Bouvier's Law Dictionary, which is the term of which I stand upon. Or however the hell you want to put him under the bus. Doesn't really matter. Or you can start asking him questions. Objection, Your Honor. What is an administrator? Is that not what you are acting as right now today in this court not of record, Your Honor? Anyway, we get into this much more deeply in other classes in the VSOF, so I won't cover how to deal with court stuff at the moment. So to continue, number 8, that you are not one of the people in relation to the state of which you were born and in relation to the federal government. Claiming to be one of the people in all of your documents is all that needs to be said to claim your sovereignty. That's it. Why? Because it's in all of the preambles. What does every preamble say? We the people, we the people, we the people. It doesn't say we the persons. It doesn't say we the individuals. It says we the people, which is why you'll never see people defined in any statute, act, ordinance, or code of the filthy Roman civil law. Period. Ever. Because they can't. Because it comes before them. Number 9. That you remove the presumption that allows any of them any power of attorney over you at any time for any reason. Now this gets back to the infant aspect. What is the Bar Association doing? All they're doing is administering the estates of infants. Because you haven't sued out your livery and you have not come forth as having been found to be living and having been found to have come of full age and competent to handle your own affairs. Number 10. That you want any benefit from them for any reason at any time. If you take a benefit from them, you are abstaining from being the heir. You do not want to be the beneficiary, which is what some of these moron gurus, quote unquote gurus, will try to tell people to do. They'll tell you, walk into court and just say that you're the beneficiary. Well, guess what? One of the benefits is to go to jail. That would be the stupidest thing you can possibly do. The two most powerful positions you can ever hold are people, one of the people, and not even heir, but grantor. Now, technically, the heir does come before the grantor, but from a standpoint of trust law, the grantor has all the power. But the grantor only comes from the aspect of being the heir of the estate to begin with. So I elaborate on this much more in the presumptions class, which I won't recover now, but just know that those are the most powerful positions. So if you take a benefit of your own estate, you are inadvertently waiving your rights as the heir of that estate, for the heir is the most powerful and proper status you have instead of the beneficiary. And there is a specific term called beneficium abstinente. You can look it up in Black's Law Dictionary. Beneficium abstinente is where when you take a benefit, you are abstaining from being the heir. Meaning, like, you don't want to take on the debts and so on and so forth of the estate, right? That's one way of looking at it. Another way of looking at it is that you're not claiming all of the lawful titles to everything that is of that estate. And again, as a reminder,
The term estate means everything that a man owns or everything that a man or woman owns in law. Okay, that is your that is your estate. It's everything. It's not just land, which is what a lot of people have misconstrued, and the attorneys has tried to misconstrue that term to mean. Meaning an estate is, oh, it's a landed estate. Well, a landed estate, yes, is a separate different term. But they try to make the term estate mean just land. It's not just land. It's everything you own in law. All of it. So number 11, that you are subject to statutes, acts, ordinances, and codes. We as sovereign Americans only uphold public, common law, and natural law. We are not subject to the law merchant, maritime admiralty law, military law, ecclesiastical, or equity, unless, of course, under a valid contract, trust, bond, oath, or pledge, or agreement can be brought forward to prove otherwise in a court. That's the aspect of equity. Equity is the aspect of trust. There's various different aspects of which you can express a trust. One is contract, another is a bond or a pledge or an oath. Have you done this knowingly and willingly with full consent and with full knowledge? If not, with full knowledge or with full consent, it cannot be considered to be held over you. That would be a contract under duress if it was forced upon you, or without knowledge, it would be an unlawful contract not based upon consideration and understanding of what you'd entered into. Both of which are can be sued out and destroyed under tort law, or an action of tort. 12, that you are bound to any of the unrevealed contracts, trust, pledges, bonds, or oaths that they try to hold over you as an infant. For no contract that you may have ever had with the corporate government can ever be held valid because you used Federal Reserve notes at a time for any of the contract, quote unquote, licenses. It automatically avoids the contract for lack of valid consideration. Did you go and get a driver's license when you were 16? Okay. Did you pay worthless Federal Reserve notes to enter into that contract? Great. That means you didn't give them valid consideration, meaning gold or silver, for that contract. It's instantaneously null and void. Number 13, that your estate is considered abandoned and not claimed and therefore requires administration. That gets back to the presumption of abandonment, which we've already covered. 14, that anyone has come forward with a superior claim to your estate. The attorneys cannot claim your lawful estate. They can dare say that they're the administrators of the estate because no one else has come forward to claim it, and we don't know what's going on, so therefore we're going to place it into a trust, a certificate by trust, until what? Until the heir has come forward, has been found to be living, and claims their estate and sues out their livery. But no one can claim a superior claim to your estate. No one. So, if anyone does so, and you place that first and highest claim on your estate by the VSOF Status Docs, they must come forward and, they must, by the contract and by the Status Docs, let go and lose claim of any hold or control that they have ever held over same. And if they do not, you can place a $300 million liability over each and every single one of them who dares to administer or does administer your estate, or who does not give a full accounting of what they have administered in the past regarding your estate. We have done this. There are men who hold now binding arbitration awards over sitting judges for their entire estate. And I can prove it to anyone who wishes to ask me for the proof. 15, that you consent to any administration of your estate. That means at any time, at any point, in any situation, from now until infinity, period. Again, this goes back to consent. Do you consent? The status docs say you do not. If you go back and return back under contract after you've done the status docs, that's a different story. That is your will, that is your choice, that is your decision. So be it. But do not come crying to us or me if you chose that, if you take and choose that decision and go back under contract to them, to the attorney, after you've done what you've done to get yourself out of it. 16. That you are a 14th Amendment citizen, subject to the jurisdiction of the corporate Congress under the 14th Amendment. If you read the 14th Amendment very clearly, and then at the same time or prior to or right after, you read what is called the Expatriation Act. The Expatriation Act was the out of the 14th Amendment for the attorney, because they were well aware of what they did after Reconstruction and with the 14th Amendment when all of the southern states were denied suffrage in the Senate because they were forced to come back, and sometimes the southern states were had actually been placed into the southern states, various different legislators, congressmen, if you will, who had not been lawfully voted in. The 14th Amendment was never properly ratified. You can prove it. And the 13th Amendment, the original 13th Amendment, which I don't have in here, but the original 13th Amendment was ratified, which is not the abolition of slavery, but is the reaffirmation of the clause of the Articles of Confederation, which clearly state that no one who holds title to a foreign prince or principality can ever hold office in the United States of America. Every single filthy attorney holds the title of Esquire, which is one under a knight, from the filthy, illegitimate Rothschild cunt who sits on the throne of England, who hopefully is already dead or will soon be ousted by the legitimate heir to that throne, who I am well aware of the fact who has come forward and done his documents to prove the same. We shall see what happens in 2021 with that. So, now, there are other presumptions not listed here in the status docs that also get corrected. So, the order of the process. The order in which one should complete and file these documents so that they can accomplish the entire process is as follows. Everything in red gets filled in with the first round of the filing. Actually, we've slightly altered this. So these first rounds of filing, we've made it so that now anyone who comes in and does the status doc set, you can file them all at one time. There was a time in which we were doing this in parts and parcels. So this particular handbill needs to get updated from a standpoint that you can file everything now all at once. But in the order of which these are, they're still there for a reason. So I'll just go through them. So you get your house seal made from an office supply store. 2, you get 3 copies of your birth certificate authenticated on both state and federal level. And you can see the handbills for the birth certificate authentication from the Vocational Science of Freedom mega server. 3, when you get those house seals back from the office supply store you ordered it from, you will fill out the seal notice. Then you'll appoint your coroner of your house, and you'll fill it out as per the judicial coroner appointment. 5, you'll convene a petite grand jury of 12 other people who have come of full age and sue out your proof of life and proof of age inquest before the judicial coroner and the petite jury. Now, in the day and age of COVID and all this other ridiculousness, and the simple fact that we now have technology to do this, you can do this online. You can do it through webcams and everything else, because anyone needs to see any other human being. They can clearly tell that, yes, they've come of full age, and yes, they have been found to be living, which is all the proof anyone ever needs to fill out any of these documents, okay? Now, we've decided that we will organize groups in the various different places of the nation, East Coast, Midwest, West Coast, Mountain and West Coast, in the next year, in order so that people can physically come together and sign their doc set if they wish to. And all the better, because every one of us should be able to do this in each and every one of the states and there should be no reason by the end of this year why we do not have at least 25 members of the peerage in each and every state. 6. You'll file your birth certificate claim, which means you have to have the state and federal authentications of your BC back before you do this because they get attached to it. 7, you fill out the rescission of power of attorney, then the executor appointment, then the fee schedule, then the kill warrant, which is properly known as the lawful claim of title, will, execution of will, and declaration of status, appointment of trustees, and standing orders for same, which I know is fairly lengthy, which is why we simply reduce it to the kill warrant, or even shorter than that, KW. 11, you'll file your declaration of nationality and oath, and then you'll file your ordinance of the estate. And the ordinance of the estate is a continuation of all of the rest of the status docs that came before it, of which all of the public record numbers will be placed into that particular declaration so that those members of the vocational science of freedom who are perhaps short of Fed Reserve note funds will only ever have to serve one single document on anyone who they wish to put under the bus, which will be the declaration, which will be the ordinance of the estate, because it will hold in it and have in it every single other public record number, so that whoever you serve has to take due diligence of all of the previous public record numbers that are in that document. Then the rest of these, you can feel free to do so as you need by your own will or by your own necessity. 1, your actual will, meaning what will happen to your estate when you actually leave this realm. Number 14, special master and marshal's appointment for your own court. That is, if you intend to or ever need to hold a court of record and establish your own court of record. 15, your state passport documents, which we have templates for, but are, depending on what happens the next week, might be difficult to get, but we'll cross that bridge when we come to it. Number 16, your SS4 form, which will give you your 32 EIN estate number, which will override and alter your Social Security number. You will then get a letter from the IRS stating that you are the executor of that estate. We have proof of this. Many men have done it, and those that have done it and then served the doc set on others have had over $40,000 in debt wiped out instantaneously, and the entire account has been ghosted, meaning it no longer existed. There could never even be found a proof that it even existed after that fact. Why? Because attorneys are not stupid enough to cross estate and trust law. 17. If you want out of property taxes, we have templates in order to declare your lands to be allodial if you actually own your own lands, and that's a whole nother process. And then the rest of this document goes into how you do the sign and the seal and where to put your initials and how to fill out the documents, of which I'll not read for the rest of it because it is fairly lengthy, as you can see. So from that, that's the totality of the status doc set in a very condensed version. I will have the rest of the vocational science of freedom full status docs set class, meaning the all-day class, of which we did, I believe, in December, might have been November, but I'm editing it now as we speak in the next week, and those who had paid for the class, I will make sure that you get your direct link to YouTube and other servers to make sure that you can download that class and save it on your own private records on your own computer, because you guys paid for it. And anybody else who wishes to pay for it is certainly willing, or that's willing to pay for it, can do so by giving a donation of 3 rounds of silver to the Vocational Science of Freedom, of which the address and the docs can be found in the membership and prices link, or sorry, membership and prices room on the Gilded server under VSOF information. And if anyone has any particular questions regarding the doc set, you're always welcome to ask me, notify me, and do a direct message on the Gilded server. Just click on Zen Master and then go down to, or sorry, right click on, I believe it's right click anyway, it's either right or left click, and then just go to message, and you can direct message me about any questions you might have regarding the doc set. And with that, I will conclude the recording for tonight and make this the end of it. Thank you everyone for showing up, and we will continue for the rest of the night with the questions and answers, the Q&A sessions after we conclude, after I cut off the recording. And those Q&A sessions can be found on the VSOF members section in the Gilded server if you're a VSOF member. So I thank everybody for showing up tonight, and I will turn off the recording, and afterwards we can talk amongst ourselves.